So I'm now joined by Andrew Moyser, and Andrew is a partner at the accounting firm MHA MacIntyre Hudson. So Andrew, tell me a little bit about MHA MacIntyre Hudson and the type of firm that you are.
Okay, sure. So MacIntyre Hudson is a firm of accountants. We're in the top 20 in the UK in terms of, ranked based upon our turnover. In the last 10 years, the firm's doubled in size, mostly through acquisitions, but there has been a lot of growth internally. Around 5 years ago, the firm set up a national network called MHA, and about 3 years ago, we joined the Baker Tilly International Network.
And Andrew, you were recently appointed the Data Protection Officer for the firm, is that right?
Yes, that's right. I was appointed the Data Protection Officer about 9 months ago. Really didn't know quite what I was letting myself in for at the time. If I'm perfectly honest with you, didn't know a lot about data protection or GDPR. So I very quickly had to bring myself up to speed, get a lot of training, and find out exactly where the firm was at in the preparation for GDPR.
So you mentioned getting training, which presumably was getting yourself trained and understanding the role that you'd taken on as DPO ahead of everybody else. What was it like organising training for your staff? How did you go about making sure that the rest of the team were up to speed?
The staff is actually the hardest part. I think it's very easy for data protection officers to go out and get training, but it's how you then disseminate that throughout your staff. I tried a variety of methods, if I'm honest. We have an online portal where staff can log in, and it tracks them through the modules in regard to GDPR. I also sent around weekly short snippets. I called them GDPR top tips of the week, and that created an ability for me to send short, sharp bursts of information and really helping the staff pull together the action plan throughout the preparation for GDPR.
So passing information on in sort of snippets as opposed to trying to make sure they take on the full remit of all of the legislation in one go. Was that your approach?
Yeah, very much so. I think staff respond better to short, sharp snippets of information. And I really felt that actually by sending them a short email, asking them to do something or asking them to think about something, I was able to bring them up to speed with GDPR over a longer period of time, and they're more likely to digest it and read it.
And did you find when you did that and you notified them about one aspect of data protection or GDPR, did you notice any feedback from them of things that had happened that were sort of relevant and had to be fed into your policies because you'd highlighted them in a more sort of awareness training kind of way? Did that happen?
Yeah, very much so. I suppose the thing I sort of found early on is that when you send a short, sharp email asking people or telling people about a top tip of the week, the response rate I got from staff was unbelievable. I was getting responses from staff throughout the firm, querying me different aspects of GDPR. Right. And to be honest, it really helped me think. It helped me think about some of our key issues in the firm and how staff were telling me about some of the issues they'd identified.
So that's a good point to ask then. What were the key issues then that came up? And let's sort of focus on some of the key issues perhaps that you hadn't anticipated.
Yeah, so some of the issues I hadn't really, I suppose, let's answer the question properly. The key issues that came up were really regarding the retention of data. Throughout the very early on in the exercise, we carried out our data map, and I thought I knew where all the data was, where it was held and for how long. But when you're dealing with multiple offices, there's always a fear that actually one office may not be adopting the procedure quite like another office. And certainly staff within an office, again, might not adopt what I felt the data map was showing. So I sort of learned very early on that staff had data scattered throughout our network, and a lot of questions came back at me which weren't necessarily GDPR related, and they're probably more related to our firm's insurance policy.
Okay.
So give you an example, one of the things I sent around was the need to endorse the tidy desk policy. Now that's quite an easy GDPR tip, because obviously you don't want data littered throughout the company on everyone's desks when they go home at night.
Sure.
And one of the side things that I mentioned in that email was the need to lock away laptops, and it kind of came from an insurance aspect that our firm's insurance asked us to make sure we'd locked away laptops at the end of each day, and I kind of included it within the GDPR top tip, and I had probably more questions about locking away laptops than any other. So there were things that came up in the conversation which was really positive for the firm, but I hadn't quite appreciated were other key aspects and other key issues.
So I think that's an interesting point, and that we've mentioned in other webinars that there are some very good pragmatic, practical tips that come out of doing things properly. And if the driver is, complying with GDPR or something else, good risk management and good procedures in your organisation can often be a byproduct of that. So I suppose locking laptops away for whatever reason must be a good thing if it has an impact on both of those aspects.
Absolutely right. I think when you get into the nuts and bolts of GDPR and you start the preparation for it, what I found early on was actually it led to lots of other benefits for the firm. It kind of made you question how we actually went about things as an organisation. It highlights how absolutely inefficient we were. We were logging detailed information across various sources and systems, and a lot of it just wasn't needed. It was a tradition that the firm did maybe 10 years ago when we were much more paper-based, and throughout that 10-year cycle, the firm's become much more digitalised. Some of those old procedures hadn't actually been updated or changed, or in fact really questioned by anybody.
Andrew, we talked a little bit on GDPR Day and in other webinars that we've done about the conditions for processing. And as you know, there are 6 conditions for processing data under GDPR. How did you go about working out the right conditions for processing the data that your firm holds?
Yeah, that's a really, really important question, and it's a question you can't really answer until you've carried out that data map and you've carried out an assessment of actually what data you currently were storing and the reasons why. Most of what the firm does is under client engagement letter, and therefore for the vast majority of clients we hold data for contractual reasons. The bit where it becomes slightly more detailed is when we start looking at some of our employees and some of our contractors and the data that we're storing for them, and also some of our prospects, about some of that data that we store for our prospects. And you really have to break down what data you're storing and identify which one of the 6 legal obligations are you retaining that data for.
And what did you find when you broke that down, apart from contracts, which is probably the condition that you hold most of your client data under? What other conditions do you think are the ones that mostly applied to you?
I think the legitimate interest condition was a condition that came up an awful lot. Our marketing team were very concerned about the data that they held and they built up over years, and whether they were still able to retain it going forward. I think the whole aspect regarding marketing and whether or not they were able to retain data was an absolutely key aspect. Another part that should really not be overlooked is that of staff.
Yeah.
I think all too common, HR teams are quite quick to start classifying and start recording data regarding staff, people you've interviewed, people you've seen, people that left the firm, and actually you can quickly fall foul of some of those legal conditions if you don't have clear understanding of why you hold data, and particularly for how long you're holding that data.
So in terms of marketing for a moment, are you saying that you relied more on legitimate interest as a condition, or were your marketing team and your business development team concerned about sort of the opt-in condition and consent?
Yeah, so you raise a very valid point, and it's a point which took a long time for us in our marketing teams to understand. Most of our clients were deemed to be soft opted in terms of giving us consent to continue marketing to them. The soft opt-in clause is quite an interesting clause because the GDPR doesn't give you a clear indication of how long that should last. So most people sort of believe that the soft opt-in clause will last sort of 12 months. But for any other prospect, we didn't necessarily have an auditable trace of whether or not we'd had consent. So we took the road, as did most people in the UK, of sending out an email asking for consent to be given to the firm from our prospects and referrers. Now, that seems quite an easy process.
Yeah.
I've seen lots of examples that have come into my inbox over the last week. But I have to say, consent is actually quite something very difficult because you have to be very clear of what you're asking clients or prospects or referrers to give you consent for. And that's not just about today, that's also about the future. So our marketing team spent a long time thinking about exactly the criteria we wanted consent to be given, not just based upon what we've done over the last year, but also what was coming up.
So that's quite interesting, as you say, Andrew, because one of my questions is going to be, what have you changed? But what I think you're saying is you have to also be forward thinking about what you're doing with data and not necessarily backward thinking about what data you're holding. You're talking about what marketing campaigns or PR campaigns or what is on our horizon for the data that we're holding. Who are we going to have to contact about what in the next 12 months or so?
That's absolutely right. I think too often it's quite easy just to go out there, try and grab consent and not think about the future. But with any firm, you need to start thinking about how is the firm adapting and changing over the next 6 to 12 months. And should we be asking for consent now for something which we might need in 6 months' time? So we spent a long time debating exactly what criteria we wanted our client to give us consent for, but also giving it with enough options that they could give us consent that was clear and was auditable, but actually not too many options because we wanted to make sure that we got consent. So it's really a fine balance in getting the right amount of questions and detailed information in that consent.
So one of the features, as you know, of GDPR is privacy by design and privacy by default. So sticking with the design for a moment, what did you change, or if anything have you changed in terms of your procedures? And I'm not necessarily just talking about marketing, but what have you changed or implemented to make sure that you're including privacy by design as you go forward?
That's a great question, and it's a question which, if I'm perfectly honest with you, the vast majority of my examples would relate to the IT infrastructure of the firm. I think too often the firm has developed and adapted into ways which wasn't necessarily giving us the best results in terms of privacy by design. And I'll give you a good example of that. It's quite common for companies in the accountancy profession to engage with clients in terms of maybe helping them with their management accounts. And we'll set them up on one of our systems and assist them on a monthly basis. I suppose the thing that nobody had ever really appreciated was some of our users within the firm had actually got access to a lot of clients. And they weren't just accessing clients that were their clients, they had access to every client in the firm. So we sort of realized,
right,
as we started to interrogate the data map, that actually there were some individuals, I'd call them super users, who actually had access to far more data than they needed. And therefore that was something we could quickly change to bring in privacy by design in terms of our systems and procedures. The thing that perhaps scared me most when I started looking at this was actually the cybersecurity angle, because a lot of the outsourcing team had set up software on the cloud, and it is quite a common practice, and staff feel quite comfortable downloading apps on their mobile phones and signing up to things. And what I found is a lot of staff had signed up for cloud accounting software solutions and were automatically demoing various bits of software.
Yeah.
The whole cyber security piece really did dread me with fear. And if I'm perfectly honest with you, I looked for a solution on the market to control people's login details and to control access, because it was just becoming too unmanageable for us. And we found a suitable software solution which we have implemented, and that's really helped tighten our procedures and help bring in that privacy by design.
So that's also getting the sort of the culture change right, and making sure people actually understand why you're changing those procedures. So you mentioned earlier on training. Well, what do you think your other organisational challenges were in getting ready for GDPR? Was it bringing your partners and your staff along with you, understanding the importance of what you were trying to do, or was there something else that was an organisational issue in getting ready?
I think, if I'm perfectly brutally honest, it was breaking through the barrier of getting as much engagement from staff and partners. I already mentioned to you that I've been sending out weekly top tips and bringing people's awareness up to scratch. About 2 months in, I decided not only would I continue sending those emails on a weekly basis, but I'd also fill a few of my other fellow partners with the task of circulating emails within their own office. That actually produced certainly a different response. I found that when I sent an email, I would get responses from individuals from around the firm. But if I asked maybe the staff partners, for example, to send an email, they had sometimes much more powerful impact than I did. So actually I was using different means to get my message out there and to bring up people's awareness. The other thing I did was also to speak at as many local office updates as I could. Getting around in front of people really helped to help them understand what GDPR was. And in a lot of ways, at a seminar, they was able to ask questions which perhaps they didn't feel comfortable dropping me an email on. And it really did cause some great discussions amongst the firm about some of our procedures and how we could improve them. And if I'm honest, most people knew about the issues. They just needed a little bit of a prompt to start dealing with it.
So you went for sort of the local kind of ambassador approach of getting people that they know perhaps on a more day-to-day basis to be your eyes and ears on the ground and sort of get the message out?
Absolutely right, because at the end of the day, the DPO cannot be the one person that is responsible for bringing GDPR in. I realised that my job was far more than that. My job is to educate staff and educate the partners, and then through them, get them to think about data protection in a different way. So for me, I was using a variety of methods, and to be honest, I would use any method I possibly could to provoke a reaction. So turning up at a seminar and speaking provoked some reaction. Standing up at our partner's AGM provokes another reaction. People respond differently. Some people respond quite well to emails. Some people respond far better on a one-to-one basis. So I was just trying to use as many of those tools as I could to get that message out.
And I guess no one wants to be the firm or even the individual in the firm that's the the cause of the risk or the data breach or whatever might go wrong. So perhaps getting that message out that way helps your sort of damage limitation process as well.
Absolutely right. And in fact, you raise a very interesting question there when it comes to data breach, because I felt that since I'd become a DPO, I'd not seen enough data breaches. And that sounds quite worrying to some people, and I will rest assured that MacIntyre Hudson does not suffer and has not suffered significant data breaches in my time.
Good.
But at the end of the day, things happen.
Yeah.
Laptops, unfortunately, do go adrift at times where someone leaves them on a train, or somebody loses their mobile phone. These things are real. They do happen. Of course, we have encryption software, and in fact, most of our data doesn't sit on those devices themselves anyway. Most of it synchronizes up with the cloud. So we've not suffered any significant data breaches, but actually the reality is I've not seen enough communication coming my way. And you only have to highlight a few classic examples to people of maybe it's just simple things like an email's been sent to the wrong person, and the fact that I've not seen that data breach for 9 months told me that these things were not being reported quickly enough. And so therefore I would react with my weekly top tips according to what I felt was of highest risk and of high importance at the time. So if I felt I'd not seen enough data breaches, then my top tips would just reflect the fact that I needed to bring education up to help people understand our process for reporting data breaches, but fundamentally some classic examples of what data breaches were.
And so what you mentioned some of your top tips that you were sending around. So can you give us a couple of examples of things that have worked really well for you, maybe some of the more practical ones that have had a good impact?
Yeah, sure. I mean, I've sent around an awful lot over the last 9 months. I think the one on data breaches was interesting. When I sat down and thought of a few classic examples of things that I expected to see, such as an email going the wrong way or to the wrong individual, such as maybe we'd lost a USB stick, lost a mobile phone. Those things provoked a lot of reaction. The tidy desk policy one, I have to say that probably provoked the most reaction. When you tell people they have to have a tidy desk and it's for data protection, that email I actually got the staff partners to send, if I'm honest.
Right.
I knew if a staff partner had sent it, it would provoke more reaction than if I'd sent it. And that one really did cause a stir. The last one is each individual within our firm has their own private drive where they can store data in, and it's only accessible by them. And I realised that was a high risk because whilst I could systematically go through some of our electronic filing cabinets and look at what was old, the stuff within each individual drive was a lot harder, and we sent quite a strong message to staff, basically telling them that they couldn't have anything to do with a client in their personal drive.
Right.
And that provoked so much reaction. It was quite clear to me that staff had been putting data in their personal drives, predominantly so they could upload things to emails and stuff and make things easy. But we took quite a hard line on that. And not only did I send that email, but I also then spoke to some of the sort of employee forum members within each office, and they also drove that whole process. And that really, I have to say, that's the one process that I got most reaction to. And in particular from partners, if I'm honest. Partners have generally been up and down when it came to feedback, but that email provoked so much reaction that I knew it really hit the spot.
I guess it's the realization that if you're doing something like that, then in a firm the size of yours, if other people are doing the same thing, the potential for having data in the wrong place or not being properly auditable must be huge.
Absolutely right. And at the end of the day, people are people. They don't do it to cause a problem. They're not trying to breach the data protection laws. They're not trying to cause a complete mess when it comes to filing system. People will just take sometimes the easy option, and for too long nobody challenged them on whether or not they were doing the right thing. And I think a few emails like that, asking the questions and asking people to remove them, I think for me it's just helped the firm. For me, it's not just been about data protection. This has been about helping the firm understand where we file things, how long we file things for, and who has access to them.
So it sounds like it's been a positive approach, and the impact of GDPR was perhaps a catalyst for you in terms of making changes and getting those changes through that you wanted to make anyway.
Absolutely right. I think at the end of the day, you can look at the GDPR legislation or regulation, and it's common sense, if I'm honest with you. It puts the power back into the individual's hands. And when you look at it at a firm level and you say, right, let's prepare for GDPR, let's make sure that we're on top of this. And you then realise that over time, a firm develops. And a firm, it doesn't mean to. As I said, people are humans, and humans always take the shortcut. They always try to do the best. But naturally, over a period of time, you find that we just clutter things up, and we don't put things in a systematic way. We don't give enough guidance at times about where things should be filed. And using GDPR as the excuse, we're able to sort of grab that and actually say, right, let's make a policy. Let's make sure people know where they should be filing things. Let's make sure people do clear up their filing cabinets and their drives. Let's just make sure that we are only recording data in one place and we don't need to record it all over the shop. I think I said earlier on that the firm grows through some tradition, and some of that tradition has been very much a paper-based tradition.
Yeah.
And as technology's improved, everything's become far more digitalized. And there's a tendency, if I'm honest, that people retain digital data far longer than they should, and certainly far longer than they would if it was paper-based.
So that's a very interesting question, and I wanted to ask you. You mentioned changing procedures and so on within the organisation, and a lot of what you've spoken about is within your own firm and culture change. What have you found the impact to be amongst your client base and other people that you're dealing with? In particular, do you think that you're set up for or ready for the rights of the individual in respect of GDPR? And do you think that the people that you're communicating with are aware of what their rights are versus what your obligations are?
It's a really interesting question, and if I'm honest with you, it's a very mixed reaction. I think some clients and suppliers have really surprised me. Some of our clients have been quite on top of things, asking for new contracts, a new privacy statement or privacy policy. They've really encouraged me that actually they're on top of it. Other clients, I'd say, I'm perhaps a little bit disappointed. Some of our large clients, where some of their emails asking for consent has not been as detailed as I would have expected.
Yeah.
And kind of highlights to me, certainly given the time, that perhaps GDPR has taken them a little bit by surprise. There's quite a few other clients and suppliers out there that I see that really have been quite silent, and I think perhaps GDPR has not been people aren't as prepared for GDPR as perhaps they should be.
Okay.
And I think the press and media has certainly picked up on it over the last 6 months and really ramped things up. But there's lots of people out there that really don't understand GDPR, or they just think it only applies to the big multinationals. They don't realise it impacts on every business, and they've not taken the steps ready, for come Friday.
So you talked about training everybody and having everybody aware of what's going on. Are you ready, for example, if one of your clients, an individual client, makes a subject access request? Do you have a procedure in place for how to process that request?
Yes, we do. And in fact, as I'm sure you know, subject access requests are not necessarily anything new. I dealt with a subject access request only last week, and the challenge is identifying where the data is and extracting it quickly enough. 30 days is not a lot of time, and you need to make sure that you've gathered all that evidence and all that documentation together so that you're able to provide that in good time and in accordance with your legal obligations.
And I suppose the other main right that has come about, which isn't also entirely new, but has changed slightly under GDPR, which is the right to have your data erased. Do you think there's enough awareness about the extent of that right?
Yes and no. There's lots of misunderstandings about that right. And to be honest, that was one of the issues that I really had to try and understand early on, was what would I do if a client came to me and said, I have a right to be forgotten, go and delete my data. And the problem is it clashes with a lot of other existing law. So unfortunately, in the accountancy profession, you can't just delete data from a client just because they have a right to be forgotten. You have legal obligations to keep that data. Having said that, when it comes to contacts or prospects, and they come to you and ask that they have a right to be forgotten and they want to be deleted, then you have no excuse. And in fact, in those circumstances, you're most likely to have to press delete. I honestly don't think clients or individuals out there really understand those rules. I think there's lots of people talking about them, but nobody has really fully understood them. And I think whilst I expect post-Friday there to be an increase in these types of requests, I don't think it's going to be the true ramifications are going to be known for quite a few months.
Okay, so it sounds like MHA MacIntyre Hudson, you're ready to take on that role. I hope you've kept some time back for some other tasks, and it's not just about being DPO, and you've got some time for doing some other work, Andrew.
Yes, unfortunately I do have a day job. DPO is something I took on for the firm. It was something that actually, as I said, I really didn't understand that role fully when I said yes, I'll do that role. but it's something I've really embraced, and actually it's been eye-opening for me. It's been fascinating. But I do have a client portfolio. I do have an office that I look after. So therefore, for me, being DPO is just enhancing my passion for the firm and my passion for us to move forward and develop and do things properly.
And as is sort of evident, it's giving you very good coverage and an overall picture of what's going on in the firm. So it's interesting that from the firm's aspect as well, they're getting somebody who actually knows the client and the business processes and has a stake in the firm's survival and protection and success, actually looking after the data side of things as well.
Absolutely. It has been eye-opening for me in terms of getting around some of the other offices and some of the individuals. It's been truly fascinating to understand how, as a firm, we've developed, and whilst the vast majority of our systems are the same, there are little quirks going on within each office and within each individual. I've really enjoyed, if I'm honest, my exposure around the firm now. So when I go to any office, they all know who I am because they've all seen my emails about GDPR. And I often get queries come at me as I'm walking in the door of an office asking me about some GDPR stuff. And so for me, it's been really exciting, and I have to say I've really enjoyed it.
Good. And I think that's all that we wanted to ask you in terms of GDPR from a very practical perspective. So thank you very, very much for joining us. Is there something, one final sort of takeaway tip that you could give to everybody as your main thing that you've learned about GDPR or that you think is important, post the 25th of May?
Absolutely. For me, the GDPR 25th of May, it's not over. GDPR gives you an opportunity to look at your business, look at your processes, and actually think long and hard about whether they're right and fit for purpose. Come 26th of May, life doesn't stop. And in fact, whilst we may have got everything ready in preparation for GDPR, we have to carry on embracing this and carry on checking to make sure that new improvements and new processes can be brought in to keep the firm growing and keep the firm strengthening up on data protection. Okay, well, Andrew, thank you again for joining us. We're very grateful. Thank you very much.